Welcome to this Regulate lecture, Introduction to Intellectual Property in the Context of Robotics and AI. I'm Dr. Luke McDonough from the LSE, and today I'm going to take you through the various forms of intellectual property that apply in this context. We will proceed for the next 15 to 20 minutes, and I will guide you through each intellectual property right. But to begin with the second slide, you will see that the environment that we're talking about here, that is of robotics and AI, is highly dynamic, research-intensive, and collaborative. As such, intellectual property rights play a very important role in sustaining, encouraging, and maintaining this research ecosystem. It is very important that you and your collaborators make clear to one another which intellectual property rights apply and, even more important, who should own them. Moving swiftly on, you will see that there are actually 5 different types of intellectual property that are of relevance here. The first one that we will look at is the patent. The second one is the trade secret. The third is copyright. The fourth is trademark. And the fifth is the law of registered designs. And as we shall see, each of these intellectual properties has its own unique features. They are supposed to do different things. As we'll see, patents usually apply to hardware. Copyright usually applies to software. Trade secrets can be other know-how and information. The trademark will apply to your particular logo, name, or brand, while designs will generally protect the look and feel of the product that you have created. So it's important for you and your collaborators to know what IP right you're dealing with in each particular case. And so to begin with patents, these are registered rights. They do not arise automatically. You have to apply for a patent at your national patent office or within Europe at the European Patent Office in Munich. But despite the fact that it has European in the title, the first thing to note is that this is not actually an EU institution. The European Patent Office is a wider organization that includes several countries like the UK and Turkey that are not members of the EU. But most companies that are in operation in Europe want a patent that covers as many European territories as possible. And so it's very likely that the first port of call for your patent application will be the European Patent Office. So you have to apply for a patent, and it can be a relatively expensive process. Depending on how wide you want the protection, it can cost anything from a few thousand euros up to 15, even 20,000 euros to cover all of the territories within Europe. There is currently an ongoing project called the Unitary Patent and the Unified Patent Court, which is hoped will bring down the cost of patenting across many European jurisdictions. But this project has only just begun, and we'll have to wait and see how successful it will be. The key thing to remember if you're going to apply for a patent is that generally patents cover inventions. Usually inventions will be some physical piece of hardware in the context of robotics and AI, but it can, in some circumstances, also apply to elements of software. But those cases are much harder to apply for and to prosecute successfully. It's quite a technical process. You have to hire a patent attorney to write the patent application for you. And the reason for that is that the patent application is full of scientific as well as legal documentation. Moving on to my next point, I just want to reiterate that even though you apply to the European Patent Office, if you want to validate your patents across the EU, you need to do so at every national patent office post-grant. So you obtain your patent at the European Patent Office, and then you validate it nationally. You will also litigate the patent nationally. So if, for example, somebody is infringing your patent in Germany, then that's where you will take your court case to stop them from doing that. As I mentioned, there is a current project, the Unitary Patent and the Unified Patent Court, which only got going this month, and therefore it's very early days. It's too early to tell whether this will be a success. But the idea of this project is to make it easier to create a one-stop shop for patenting in Europe, so that you go to one court, you get one patent, and that covers almost the entirety of the EU. In order to get a patent, your invention has to satisfy the key criteria of patent law. These three criteria are novelty, inventive step, and industrial application. The way that it works is that after you've created your invention, you will talk to the legal officer at your company, or if you're at a university, you'll talk to your technology transfer office, and they will apply for the patent on your behalf. Usually, individual inventors work with others to get the patent application done. And in the patent application, your patent attorney will specify that your invention is novel. And what that means is that your invention is new. You have done something that nobody else has done before. The way the patent examiner will check this is to go through the database of existing patents, existing publications and journals, and other prior art. In other words, the examiner will check to see whether what you've done really is new or not. If somebody else has already made your invention, even if they're on the other side of the world, if that has been published, then unfortunately that destroys the novelty of your invention. It's not really new if somebody else has done it. But assuming that you pass the test of novelty, the next thing you have to do is pass the test of inventive step. So even if what you have done is new, is it actually inventive or is it obvious? In other words, would a scientist working in that field of technology agree that this is a step forward in the technology? Not only has this not been done before, this would not have seemed obvious to a person skilled in the art. So the examiner will ask that question, and presuming your invention passes that test as well, you then move to the third criterion, and that is industrial application. Here the examiner will ask, is this invention actually useful, or is it more like a discovery? Something like Einstein's theory of relativity was new, was certainly inventive, but it was not actually something capable of industrial application. It was a pure theory. And discoveries and pure theories are not meant to be the subject of patent law. Patent law is meant to protect useful inventions that have some sort of industrial property. So you need to specify to the examiner what that use is. It might be it speeds things up, it works more efficiently, it allows you to calculate a number or a figure in record time. It doesn't have to be detailed entirely, but you do have to give a specification of what that industrial application is. Moving to my next slide and my next topic, we'll now focus on trade secrets. So for certain inventions and intellectual property, patents will make the most sense to use as a way of protecting your invention. But for others, trade secrets will make a lot more sense. And these are actually unregistered rights. There's no Office of Trade Secrets. You don't apply for a trade secret. Instead, these are protected through legal orders, contracts, non-disclosure agreements. In other words, these are protected not through legal rights as such, but through personal agreements and contractual agreements and employment contracts. The benefit to trade secret protection over patents is that there's no application, which means there's no cost. You remember I said that it can cost many thousands of euros to even obtain a patent in the first place. With trade secrets, because there's no application, there's no attorney other than your normal attorney at your company or your university, you're simply using a contract to bind the other person and to prevent them from revealing the information. There is also a looser test for trade secrets. There's no such thing as novelty or inventive step here. Even something that might not meet those standards could still be protectable. There is still a set of criteria that you have to meet, but it's much less rigorous than for patents. Generally, what we're talking about with trade secrets, as you can see in the next slide, is confidential information. The idea is that you have trusted your employee or your agent with certain information. And the value of that information is that it is secret. And you want to keep it secret. If your competitors find out what that information is, it could be very bad for your business. Some very famous trade secrets include the recipe for Coca-Cola and the Google algorithm. Nobody is able to access the Google algorithm. It's kept within the company. Not everybody within the company has access to it, let alone people outside. And as a result, the Google search engine has been protected for more than 20 years. If Google had applied for a patent on their search engine, assuming that they would have met the criteria, that protection would have now expired. So you can already see the usefulness of trade secrets as a way of keeping your intellectual property protected for a much longer period. Across Europe, there's a mix of legal regimes to protect trade secrets. Some countries use unfair competition. Some countries use breach of confidence. There's also an EU directive on trade secrets, which harmonizes the key principles across the EU. The key element of that directive is a test for what is a trade secret. It has to meet 3 criteria. As you can see in the next slide, number 1, it has to be secret. Number 2, it has to be of commercial value because it is secret. And number 3, you need to have taken reasonable steps to protect the secrecy. And that may have been through putting a term into an employment contract or making somebody sign an NDA. So that's trade secrets. We now move on in our next slide to copyright law. This is also, believe it or not, an unregistered right. It arises automatically once the author has created something which is classed as an intellectual creation. In other words, something original. It could be a piece of writing, it could be a piece of music, or in the case of AI, it may be a piece of software. Software is protected under copyright because the underlying code is seen as a form of writing. And so software is one of the key copyright works that you will be using. Many of you may be aware of free and open source software, something we'll mention in the main lecture. All free and open source software is protected by copyright. It's just licensed on a free or open basis along down the chain. The duration of copyright is a lot longer than patents. It's 70 years plus the life of the author. So if you write a piece of code, that piece of code could be protected by copyright for your life plus another 70 years. So for many pieces of copyright, protection can be anything from up to 150 years. Moving on to trademark law. This is a relatively straightforward area of law and will apply in this context of robotics and AI mainly to your company name or your logo. Like patents, these are registered rights. You have to apply for a trademark. However, unlike patents, these are harmonized within the EU. So you apply to the EU Intellectual Property Office in Alicante for a trademark. In the trademark application, you specify what the symbol is that you want to register, the name or the logo. And you explain the class of goods for which you want to register. So it might be for software and computer services, for example. There is an application cost, as there is for patents, but it's much less in the case of trademarks because it's much less technical. So yes, many people will pay a trademark attorney to do the filing and do the application process, but usually this doesn't cost more than a couple of €1,000. The application fee is under €1,000, and because of the relative straightforward nature of trademarks, the attorney fees are not as high. The fifth and final version that we'll talk about in this introductory session is registered designs. Like trademarks, these are registered rights. They are harmonized within the EU, and you apply at the EU Intellectual Property Office in Alicante. These rights last for a much shorter time, initially only 5 years, though you can renew the protection for up to 25 years. The application cost is also less, usually only about €350. And the key element of a registered design is that it protects the appearance of the product. In other words, its look and its feel, not the inner workings or anything to do with the underlying code, simply how it looks. And as we'll see in the main lecture, as AI is integrated with smart robotics and we're getting consumer robot products, the look and feel of the product is quite important. There are criteria for protection, but these are generally easier to satisfy than in patent law. You do need to show that your registered design is new, so that you have created your own unique look and feel. You haven't just copied the appearance of somebody else's product. So looking ahead to the main lecture and bringing this one to a conclusion, we will look again at all of these categories, but in much more detail, and we will look at some case law. Thank you for listening to this introduction.